3 children died in a house in Duxbury, Massachusetts. Their mother is charged with killing them. Her own lawyers do not dispute that she did it, and tomorrow morning, a jury still has to decide whether she's guilty of anything at all.
But, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate to
Am Demi Thorne, and this is darkly retold. Lindsay Clancy's trial opened this week in Plymouth Superior Court. There is no mystery in it, no question of identity, no alibi, no second suspect. Her defense has offered to concede the Commonwealth's evidence outright.
The circumstances of this horrific act are not in dispute.
What the jury has to settle is something else entirely. Whether, on January 24, 2023, she was criminally responsible for what she did.
I have indicated repeatedly that we stipulate to every piece of evidence that they want.
The facts are largely agreed. On January 24, 2023, in a house in Duxbury, her 3 children died. She was 32, a labor and delivery nurse at a Boston hospital. She survived that night with injuries that left her paralyzed from the waist down. 2 weeks later, she was arraigned from a hospital bed, masked, over a video link. She has been held without bail ever since, in a state hospital, not a jail. The 4 months before are where this case is actually fought. Beginning in the autumn of 2022, Lindsay Clancy was treated for anxiety and depression by more than one prescriber. How many medications she was given depends on who is counting. Her defense attorney said 13. Her own civil complaint says 11. Her husband's civil complaint says 9, 8 of them inside 3 weeks. Those 3 numbers have never been reconciled, and this film is not going to reconcile them. What they agree on is the shape, a regimen that kept changing, across more than one prescriber, in the months before January 24th. Patrick Clancy is the children's father. Days after they died, he asked the public for something almost nobody asks for. He later told The New Yorker, "I wasn't married to a monster, I was married to someone who got sick." He has since divorced her and remarried. In January, he sued her psychiatrist, a nurse practitioner, and 2 health organizations, alleging they overmedicated her. She filed a suit of her own, days apart, against the same providers. And on Monday, he is expected to be the Commonwealth's first witness. Here is what a Massachusetts jury is actually asked, not whether she was ill. Illness is a diagnosis. Responsibility is a verdict. They are not the same question. The standard comes from a 1967 case, Commonwealth versus McHowell. A person is not responsible for criminal conduct if, as a result of mental disease or defect, they lack substantial capacity either to appreciate the wrongfulness of their conduct or to conform their conduct to the requirements of law. 2 prongs. Could she understand that it was wrong? Or, understanding it, could she stop? Either one on its own is enough, and the jury will be instructed in these words that mental disease or defect is a legal term, not a medical term. It need not fit a formal diagnosis. Then the part most people have backwards. In Massachusetts, she does not have to prove she was insane. Once the defense raises it, the Commonwealth has to prove that she was responsible, beyond a reasonable doubt. Is harder than it sounds, and the rulings before trial made it harder. Her lawyers asked for 2 trials, one on the acts, a second on responsibility. The judge said no. The evidence, he ruled, could not be cleanly divided. So a single jury will hear all of it at once, and then be asked to hold apart 2 things it was never allowed to hear separately. They also asked to call other women who had lived through postpartum psychosis. Denied expert testimony only, and the Commonwealth won an order barring any defense expert who had not been properly disclosed. Has worked before. In 2001 in Texas, Andrea Yates's 5 children died. A jury convicted her of capital murder in 2002. 3 years later, an appeals court threw that verdict out, not because the law had changed, but because a prosecution expert had testified about a television episode that did not exist. At her second trial, in 2006, a different jury found her not guilty by reason of insanity. She has been in a state hospital ever since. Every year she is entitled to a hearing on her release. Every year she waives it. But Texas asks a narrower question than Massachusetts does. Texas asked only whether a defendant knew that what she was doing was wrong. It does not ask whether she could stop. Massachusetts asks both, and when researchers reviewed 34 of these cases, they found the legal standard was almost never what decided them. What decided them was whether the jury accepted that the psychosis was real. Is worth being clear about what each verdict does. Guilty of murder in the first degree, in Massachusetts, means imprisonment for life, with no eligibility for parole. Not criminally responsible does not mean she goes home. It triggers commitment, a 40-day examination, then a 6-month order, then renewals. And the jury instructions say it plainly. There is no limit to the number of such renewed orders, as long as she remains mentally ill and dangerous. Neither path is a door out. As of tonight, 2 evidentiary fights argued on Friday are still unresolved. How many first responders the Commonwealth may call, and whether an expert may perform a demonstration in front of the jury. The trial is expected to run 6 to 8 weeks. More than 200 names are on the combined witness lists. 12 of the 18 people seated this week will decide it. Not did she do it, that is conceded. Not was she ill, that is a diagnosis, not a verdict. Whether, on that day, the law can hold her responsible. I'm Demi Thorne. This has been Darkly Retold.